Hello, my name's Alex Mullock, and one of my main area of research so far has been on sort of end-of-life law and ethics. So basically what I'm going to do now is talk to you about the Assisted Dying Bill, and particularly about the role of the physician within the proposed law. And what I'm going to say is basically a truncated version of an article that I've just had published in the Journal of Medical Ethics. So if you are interested in what I say, you can read the full version in that journal. And just to tell you a little bit, first of all, about where we're up to now with the current law and what Lord Falconer proposes. The reason why I've approached this very, very difficult issue from the sort of perspective of the medical profession is because of the very important medical opposition towards any form of assisted dying. The medical ethos is sort of generally characterised by the ethic of caring, not killing. And for example, the official position of the British Medical Association states that permissive reform is contrary to the ethics of clinical practice, as the principal purpose of medicine is to improve patients' quality of life, not to foreshorten it. And that is currently supported by the prohibitive law in relation particularly to the Suicide Act, which makes it an offence punishable by up to 14 years in prison should anybody attempt or encourage or assist a suicide. So the background to the context of this debate comes from the current blanket ban. And note that the wording of the bill is the Assisted Dying Bill, not the Assisted Suicide Bill. And in fact, what they're actually talking about is physician-assisted suicide here, not euthanasia, which is legally murder, but rather the offence under the Suicide Act. And Lord Falconer's proposed reform would create an exception to the prohibition on encouraging or assisting suicide for physicians and other healthcare professionals who might find themselves involved should it become law. So the other important legal sort of thing that you should be aware of are a number of very important human rights challenges against the law. So going back more than a decade now, Diane Pretty sought to have an official statement from the Director of Public Prosecutions that her husband would not be prosecuted should he assist in her suicide. She failed, and the reason why she failed, even though the European Court of Human Rights recognised that her Article 8 right to privacy and family life, which encompasses an autonomous right to make decisions about one's life and even about how one chooses to end one's life in a negative sense. So even though the European Court recognised that her Article 8 rights were breached, they said that the law in England and Wales was justifiable because of the need to protect vulnerable people. And I'll come back to that issue. We've also had a human rights challenge by another brave lady called Debbie Purdy, who sadly died last year. And then most recently, a group of men, Tony Nicklinson, Paul Lamb, and a man known as Martin. And I'll come back to this case as well. And they've all successfully, in a sense, managed to convince the court that their Article 8 rights were breached by the current ban. However, that's as far as they've got. So Lord Falconer's bill proposes to legalise physician-assisted suicide for terminally ill people who have 6 months or less to live. And this follows on from his previous attempts to have some form of assisted dying legalised. So, for example, back in 2008, he tried to have an amendment to the Coroners and Justices Act 2009, whereby it would be legal for somebody to compassionately assist one another to travel abroad for an assisted suicide in Switzerland. So he failed in all that, and then he chaired an assisted dying commission, which was a sort of supposedly independent commission, but actually it wasn't very independent at all, although they did take lots of evidence from people who were independent. And the upshot of that commission was this bill that I'm talking about now. So the bill was introduced to the House of Lords in 2013. Then in the early summer of 2014, we had the decision in the Nicholson conjoined appeals, which basically sent quite a clear message to Parliament that Parliament must address this ongoing breach with Article 8 of the European Convention. So the bill had its second reading in July 2014, and it reached the committee stage last autumn. And it's progressing, however, it will run out of time, but we can expect to see it again in the future, and I'll come back to that at the end. So to tell you a little bit more about Lord Falconer's assisted dying bill, it is intended to allow terminally ill, mentally competent adults who are expected to die within 6 months to have access to physician-assisted suicide. The terminal illness is defined by the bill as an inevitably progressive condition which cannot be reversed by treatment, which sounds quite straightforward, but actually I think there are potentially problems there in terms of defining what an inevitably progressive condition is. Well, life is an inevitably progressive condition in some respects. And what reversed by treatment actually means. So there are lots of difficulties with interpretation. The person seeking to die must have a clear and settled intention to die. And it's interesting that the suggested amendments to the bill really try and emphasise that there should be absolutely no doubt whatsoever that this isn't a medical treatment, but it is going to lead to the death of the individual. I'll come back to that point as well. And then importantly, as far as doctors are concerned, it requires the approval and cooperation of 2 doctors, and one of those doctors must actually write the prescription for the fatal drugs which will obviously lead to the death of the person. Now this is, the amendment to the bill requires, rather than medical professional approval, is supposed to require judicial approval. But it will still obviously involve the approval and cooperation of the doctors involved. And also, if we think about the way that physician-assisted suicide in reality and the practicality of that, it will also require the involvement of pharmacists, and it might require the involvement of other medical professionals. So, in relation to what actually happens in terms of the practicalities, or what would happen should this become law, once the person who's seeking to die has made this declaration and everybody's satisfied that they're competent and they have this terminal illness that cannot be reversed by treatment, the attending doctor or other medical practitioner, who could presumably be a nurse, will obtain the drugs and deliver them to the person and help them to prepare the drugs, and they may help the patient to self-administer, but they should not actually administer the drugs themselves, because that would obviously be crossing the line from assisting in a suicide into actually providing euthanasia, which, as I mentioned at the beginning, as far as the law is concerned, is murder, which carries a mandatory life sentence. So you have to be very careful in terms of how much help is given to the patient in administering, because it must clearly be a case of self-administering. And then the assisting health practitioner must remain proximate with the person until they have either died by taking and ingesting the drugs, or have changed their mind and decided not to ingest the drugs, in which case the health practitioner must take the drugs away with them. So it's not like in Oregon, where the person has control of the drugs and can decide, whether or not to take them. Proximate means close, but not necessarily in the same room, in order to allow the patient to die with privacy, perhaps surrounded by their loved ones. So the first sort of important issue that I want to talk to you about is whether that, if it was to become law, would become a medical obligation. The Assisted Dying Bill contains a clause, a conscientious objection clause, which is almost identical to the conscientious objection clause contained within the Abortion Act 1967. And it says that a person shall not be under any duty, whether by contract or arising from any statutory or other legal requirement, to participate in anything authorised by the Act to which that person has a conscientious objection. So, conscientious objection is probably something you've heard about within medical practice, and it might be described as a medical privilege which is available under certain circumstances, provided, of course, that the patient can access help elsewhere. So we see within the law, we see two clear examples of this with abortion, and also in respect of fertility treatments, which are regulated by the Human Fertilisation and Embryology Act. And then in addition to the law, we have ethical guidance by the GMC and the British Medical Association, whereby they say as long as you're objecting to the treatment and not the patient, and as long as this is communicated in a respectful way so that you don't violate the patient's dignity, then it might be okay to object to just about any treatment. And it's all quite vague, actually. So what I've done in this article is compare the potential right to object to legal physician-assisted suicide to the rights that we know a little bit about already. And if you compare a doctor objecting to providing physician-assisted suicide to a doctor objecting to providing an abortion, we can see the clinical circumstances are very different. And so you may only object to abortion provided that the woman's health isn't at risk, and provided that there is another doctor to provide that service. And similarly, and actually just to mention, a recent Supreme Court decision in the case of Dugan confirmed that it is a very limited right to object to providing abortion, and you can't extend that out beyond the medical services. So if, for example, a manager was trying to refuse to delegate or to process paperwork in relation to abortion, that is not protected by law. So another comparison can be seen with the right to object to withdrawing life-sustaining treatment. So at the moment, one is allowed to object provided that somebody else is prepared to carry out the treatment withdrawal. And that's exactly what happened in the case of Miss B, a woman who was paralysed from the neck down and who insisted that ventilation should be withdrawn in order to allow her to die. And she won that case. But the people who were looking after her didn't want to see her die, so she had to be moved elsewhere. But if you compare physician-assisted suicide to that even, continuing to treat somebody again without their consent or against their best interest is a clear violation of their bodily integrity, which I think is probably much worse than just saying to a patient, sorry, I'm not going to give you a fatal prescription. So I think what we might see is perhaps a stronger, less limited right to conscientiously object, should this become law, which will, as I've argued with Richard Huxtable in a forthcoming article that's going in the Medical Law Review, this will present a compromise which allows professional choice and professional conscience to operate, but also will allow some limited form of assisted dying. So the next main issue that I focus on is safeguarding the vulnerable, which is which is the reason really, in addition to this kind of professional medical opposition. But the other big reason, the reason, for example, why Diane Pretty's application failed all those years ago, was that we really want to make sure that people who might be vulnerable to legal assisted dying are protected. And if we think about who's vulnerable in this context, if we have a law that allows, for example, only terminally ill people who are expected to die within 6 months to access PASS, then they are in the vulnerable group. So whoever is eligible is potentially vulnerable. So if we allow only to those who are terminally ill, as they do in the US state of Oregon, we can see certain problems. It's quite limited, so lots of people who are perhaps suffering with very serious conditions who've got much longer to live might argue that they've actually got a stronger ethical claim than those people who are going to die quite soon anyway. And also, if we're going to say only the terminally ill can die, then it's very difficult sometimes, well, often I think, to accurately diagnose how long somebody might have to live until it gets very, very close to the end. So that is a particular problem. And in studies that have been done on this in Oregon, Batan et al. And George and Finlay, and these are all, I think, in the Journal of Medical Ethics, have argued that, you know, there is a problem here because sometimes people who obtain the prescription to die in Oregon but then choose not to take it, which happens quite a lot there, have gone on to live for years and years and years. So if we think that this is really important, then that's a potential problem. Another way of limiting access to physician-assisted suicide is to limit it to people who are suffering intractably in a way that can't be alleviated by other means. So perhaps they've tried other ways to reduce their suffering and so on. And that's exactly what happens in the Netherlands, where both euthanasia and physician-assisted suicide is legal. The problem perhaps with this is that it becomes almost universally inclusive, so that absolutely everybody is in this potentially vulnerable group. And whereas we can say that if we limit it to only the terminally ill, that will exclude disabled people unless they are also terminally ill. And thereby we will avoid sending out the message that those with a disability have, you know, a less valuable life that's less worthy of protection. In the Netherlands, you could argue that because everybody can potentially go to their doctor and say that they are suffering unbearably from a condition, and it doesn't have to be a physical condition, it could be a psychiatric condition, then you're really widening out this potentially vulnerable group. And of course, those who are obviously suffering from some condition, you know, a disability, for example, will perhaps be seen to be more eligible. So there's a problem there with that approach, I think. There is a clear ethical concern. And it's also highly discretionary, because whereas if we can say, well, you have got an irreversibly progressive condition, and we can sort of identify that, if not perfectly, those who are just saying they're suffering from perhaps something that's not terminal, there's a sort of objective and subjective question there about that suffering and how serious it is. The other issue is raised in the Supreme Court decision in Nicholson, because those men who went forward, Tony Nicholson, which is a picture of him there from before he had his stroke, sadly died after his High Court defeat. But the other men who continued were not suffering from a terminal illness, but the court said they were clearly, experiencing a sort of cruel. The law was cruel in respect of their suffering, and they were having their Article 8 rights breached. So there is an argument which is recognised by the Supreme Court, even those judges who didn't want to allow the declaration of incompatibility, to say that they should actually have some access to physician-assisted dying. So it's very difficult, and particularly with issues like depression and who should decide. So just to finish very quickly, what is the fate of the assisted dying bill? Well, during the committee stage in November, there were numerous amendments that were, I think they run to about 170 odd, but the ones that have been absolutely accepted are judicial safeguards. So a High Court judge, rather than a doctor, should have ultimate decision-making power. There should be much more scrutiny of capacity because, as we've already heard today, the sort of empowering ethos of the Mental Capacity Act might presume capacity when it's not there. And if somebody is asking for something rather than refusing treatment, we may have less call to scrutinise their capacity. So the amendments stress that the capacity must be commensurate with the severity of the decision, and there's lots of changes to the language throughout. So, for example, you're not allowed to call the drugs medicine; they have to be called fatal drugs. And then just to finish, really, as I said at the beginning, the bill will run out of time before the general election, but Lord Falconer has stressed that he will be returning to the House of Lords with a new version of his bill in the very near future. Thank you.